The state's 10th witness, Sgt Mandla Masondo of the Organized Crime Division and the Taxi Violence Unit, has given testimony of how the arrest was effected of accused number 3, who is one of the 5 accused who stand accused of murdering Sgt Mandla. And of course, Advocate Mnisi, on behalf of accused number 3, then took his time in going through that detail piece by piece, going as far as asking about arrest warrants as well as that process that they used to recover the serial number on firearms. We get some legal analysis on the Sgt Mandla murder trial with Sinawo Makangela. Sinawo, thank you very much for your time this afternoon. Perhaps let's focus on the conduct of the police when effecting an arrest. And this is something that we heard also from Advocate Mnisi on behalf of his client, asking him whether a warrant of arrest or whether the police had a warrant of arrest when effecting this arrest, and this is what we heard.
Well, any conduct by the police is regulated by the what we call Criminal Procedure Act. They've got instances where they can effect an arrest without a warrant, for as long as they reasonably believe that had they applied for it, they would get it, but it would delay for them to go to court and apply for the warrant. It would defeat the purpose of effecting that kind of an arrest that they want to at that particular moment in time. So, well, of course, they considered that there was no warrant for the arrest of accused number 3 in this instance. They arrested him anyway, without that warrant.
In fact, here's that interaction, Sinawo.
You are telling this court, this trial, that when you searched him, you did not have a warrant of search, not so?
It's so.
Thank you. That is now both when you searched him in the streets and also when you searched in the room where you say the room that he pointed out to you, not so?
That is correct.
Now, Sgt Masondo wanted to bring up the case of the Alexandra matter and how this suspect was then linked to the Alexandra matter, but Mnisi was having none of it, going as far towards the end as asking the court to expunge that from the records, something the judge says, well, that it's impossible for the court to do that. But there was also, I don't know if we can characterize it as a sour moment between Advocate Mnisi as well as Advocate Baloyi, where Advocate Baloyi then stands up to say, well, the advocate made his bed, now he must lie in it, and a disappointed Mnisi saying, well, this is not something that I would expect from a learned colleague that I take in high esteem. This particular interaction, how did it assist the court? And this Alexandra matter, how did it complicate the defense's case?
Well, it doesn't. Remember, the defense is not in court for the Alexandra case. The defense is in court for the false Loras case, because I think the Meiwa case has been reported at false Loras. So it doesn't at all. What he's trying to do is to say, court, please clear your mind. Remove all these side issues. Whether somebody was arrested in Pretoria or Alexandra, it matters not, because that is not what is serving before you. The point of the matter is the sergeant considered that actually the accused of Advocate Mnisi was not implicated in the firearm that killed Sgt Mandla. That's what is the crux of this case. Either way, because the point is that it helps the state. You bring Alexandra, you leave it hanging. What evidence will be led in relation to the Alexandra case? Where does it take the state's case that is serving before court? Because the case that is in court is a false Loras case. So it's to say you've got a lot of information before you judge. Remove all these side things. Just put your finger, disregard that information. Correctly so, the judge as well. I can't disregard any information, but he says, well, okay, it's fine. At an appropriate moment, I will address you. Obviously, that address would be to say, this is a charge that my client is invited to come and answer to. This is his answer. This is the evidence that has been led. These are the elements of an offense that he had to meet. Have the state satisfied these elements? Then if not, this is what must happen with my client. That's it.
Did Mnisi manage to plant doubt or poke holes at the evidence of Sgt Masondo when it comes to the gun specifically, going as far as talking about the etching process, who the gun belonged to, the ballistic testing, etc.?
If you can look back, that is what the the sergeant considered. One, the accused, I think accused number 3, because there's no link with him in the firearm that killed Senzo. 2, there is no evidence that link the accused number 3 with the firearm that was found as well in those premises. The third point is the issue of now the search warrant. Remember, as I say, before the police can conduct the search, they need to have a warrant. But where they don't have a search warrant, there must have been an information, reasonable information. You don't just wake up and go and search somebody's premises without being authorized. But if the reasonable belief that you would get that warrant, but if you had to go and apply for a warrant, it would defeat the purpose of the search, then you can go and search. But still, there must be an inquiry to satisfy those requirements. You don't just formulate that reasonable belief. There must have been some facts before you as a police officer to conduct that search. At least from the evidence now, it's under cross-examination. There is no such an indication that when he left, wherever he left, he had this information and he formulated a reasonable belief, because reasonable belief cannot just exist in vacuum. There must be an information wherein he can formulate his reasonable belief.
Why is a search warrant so important? Because Sgt Masondo also goes on to say that he's not the one who physically found the guns on top of the wardrobe. It was Sergeant Dlamini.
Well, then it means whoever found the gun will have to come and testify in court. Remember, this is hearsay. Its veracity depends on the officer that found the firearm. But search warrant, remember the law enforcement agencies don't just, is to protect the rights of the people. Otherwise, everyone would wake up and say, I'm here in your house to do. This is what I want to do. It must be regulated. It must be guided by the law. And whatever they do, it must fit within the four corners of that very same statute that authorizes him to exercise that public function. So they have to act within the law in executing their duties. Otherwise, citizens would be victims of brutality, as we may all know.
On the conduct of the police while effecting the arrest, Advocate Mnisi asked Sgt Masondo whether he read the accused his rights. This is how that interaction went down. Let's take a look, listen.
In your testimony, there's no way where you mentioned that at a particular point we stood back and said, accused person, these are your rights. As we are doing this, just know that you have got the following right. Do you agree with me that you never explain his rights as a suspect and as a person that gets detained, or that you suspect him?
His rights were explained fully and he understood. It might happen that during the testimony it was not asked.
There was a moment as well, just shortly before, after that, where Advocate Mnisi went on to put it to Sgt Masondo that his client was cooperating and he had no choice because the police were spitting venom. More pointedly, Sgt Masondo was spitting venom, and he then, because he wanted to appease them out of a lack of a better expression, then he gave them what they wanted to hear. He also says that the police or his client will tell the court that he was not given a chance to explain his side of the story with regards to the firearm allegedly found on the wardrobe. What does that do for the defense's case? How do you prove that? Because this is not the first well, I guess he's not a witness, but we've heard from other witnesses who claim that the police meted out some brutality towards them in order to either get a confession or something of the sorts.
Well, just to start with the first issue, it is not available to the state witness to say, I was not asked a particular question. It's a procedural issue. When one's right to liberty, remember, there's what is called rights in the Bill of Rights. Anyone who tampers with those rights has a duty to prove that there was a justification to violate somebody's rights. Now, if you tamper with somebody's liberty, when he testified, he had to say, I said you are under arrest. I then explained to him that you have a right to remain silent. You have a right to contact your legal representative. It had to come from him during his evidence in chief, not to say, well, I was not asked that. Then if he did not say it in his evidence in chief, it is only coming when he's asked in the cross-examination. that may be considered as an afterthought. So again, that's another gap that has been opened by the state on the matter. Of course, there will always be, in relation to the issue of cooperation, had no choice. It's a delicate issue. Daily, we know that there would be trial within a trial. How was the information obtained? There must be a procedure as well to get the confessions, or what was going to happen if he resisted. Did he have a choice? Were they willing to take a no for an answer? Was there such a room from the police officers to say, well, I don't want? What was going to happen if he said so under the circumstances? So he must give the picture now to the court, understanding many reported cases as well as many reports from many commissions and how the police are conducting themselves once they go out there when they deal with the members of the public. So it is incumbent upon the defense now when they lead the evidence and to demonstrate as well that this is how it happened, this was the climate at that moment.
Just from the work that you do, as a side note, is police brutality, in order to draw a confession from suspects, a reality? Is it something that is abound in South Africa?
Yes, it is there daily. You can go to the criminal cases. You know, in one judgment, the judge was so furious because he says, well, in the modern world, if this person confessed to have committed an offense, why didn't you just take a video, what do you call a camera, to take a video of this person making this confession? Why do you have to use the old ways of getting this information? Because somebody says, well, I was assaulted, I had no choice. I was severely assaulted by these people, and they said I must confess to have committed this particular offense daily. And the courts are complaining that they have to waste their precious time in conducting the trials within a trial. Somebody now comes to court and says, well, I did not commit an offense. The police are saying, but you confessed. So it's something which is there on a daily basis. Because if it was so easy, put the camera, put somebody in front of a camera, somebody must tell, as is. Then that's simple.
Thank you very much for your time this afternoon. Sinawo Makangela is a legal analyst.